Greetings, 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 greetings. It is I, King Clifford Jefferson, a Senator Godfrey, the fifth Caliban Jew, the son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know is the Vicar of Christ, which I incarnated in the year January the 14th, 1970. I'm here on September 18th, 2024, which is equivalent to the birth year 2974. I greet you in the name of my Queen, Sister Galveston from the House of Galveston. I greet you in the name of my Archbishop, Archbishop Belmont from the House of Belmont. I greet you in the name of all officers, members, followers, staff, heirs, successors, family, friends, brothers, sisters, aunts, uncles. We invite you into this temple that's not made by or not confined by walls. Okay? I deem this a very privileged honor that's bestowed upon me to sit in this office, which we know as the corporation soul or the monarch. Is a very important office that we really all need to take in his totality in regards to what that means or how it affects us in this present day. This is what we do here at the Third Temple English Church of England. We make things simple, based upon concrete information, drawn from certain sources, that you can get an overall perspective of who you are, what's going on, and the part you play in it in regards to an estate that one assumed or claimed to be entitled to in reference to some type of inheritance. Okay? All that will be discussed today in today's lecture, which is called The State of New Jersey Sued for a Violation of Their Oath. The state of New Jersey has been sued for a violation of their oath based upon their oath of office and their oath of allegiance, not just to their constitution, but to the government that was here, that was based upon an unwritten constitution, going all the way back to time immemorial, a time which we speak of involving our ancestors, which are our heirs, our posterior, that created the laws of inheritance, which you will see today. So once again, I want to give honor to myself for such an undertaking in regards to standing for the people, fighting for the people, and delivering for the people what it is that the people seek. I don't think there's anyone out there that has delivered anything closely to some type of inheritance or some type of estate concerning real property claims that's associated with an inheritance. Okay? So if you haven't heard an argument spoken of on some platform in reference to some concrete claim being put forth on behalf of a representative of some society or government, on behalf of the people of that society or that government, then you really you're not doing anything for your people. This is where I come to show where we at the Third Temple English Church of England excel at. All right. So without further ado, let's get started with this marvelous lecture. I'm going to give a special honor to Brother Milligan, who always and wholeheartedly finances the king whenever need be, especially in regards to matters concerning the church. All right, he funded the finances to actually have the case filed in the civil court, as well as have the actual service of process done by the sheriff department in Trenton. I actually drove down to Trenton. If I think it was yesterday. Yeah, I drove down Trenton yesterday. Because New Middlesex County Sheriff Department would only serve within the county, so I actually had to drive down to Mercer County, where the defendant, the state of New Jersey, through their representation, the Attorney General, resides, to have him properly served by the Sheriff Department of Mercer County, which was successfully initiated. This process of service will be done sometime next week. But once again, I'm here to show receipts in regards to the state of New Jersey. It's being sued for a violation of their oath, which entails their oath of office, their oath of allegiance, as well as their contractual agreement to return what rightfully belongs to the crown. What rightfully belongs to the crown. And I being the crown representative, I'm the rightful person that the reversion of the state should be returned to based upon the concept of operation of law. So all those who gonna be with me today, make sure you're taking notes. I know I've been promising to do this lecture for a couple of days now, but by virtue of the fact of the internal business that I've been dealing with as far as getting this matter before the courts, I've been in disposal. Okay, and what matter that I speak of, I'll show you. New Jersey courts, docket number, Middlesex County Law Division, 005260-2024. Equivalent year, birth between 974. Case caption, Jefferson, King Clifford versus State of New Jersey. Civil parts, case type, as you can see here in the left-hand corner, it concerns real property. Okay? It concerns real property. All right? Real property that the state has overseen as a result of taking custody of it, as a result of it being what we call abandoned property. Abandoned property, which is called bona vacationia. And they were obligated based upon their allegiance to that government, based upon their office at the time in July 2nd, 1776, that if there was a reconciliation between the colonies and the government of the crown, that the charter, i.e. their constitution, will be null and void. Where that reconciliation was done and their charter became null and void by virtue of the fact it's only based upon a temporary basis, being that it was in the nature commemorative and ceremonial. All right, we must understand these terms. So as a result of that, the government, every state within the United States, those who were admitted into the Union and those who were there before the construction of the Union States, i.e., in that reference to 13 colonies, i.e., the 13 original colonies, which New Jersey was primarily represented as a royal colony under the authority of what we call the Crown. Okay? Under the authority of the Crown. We must understand that, being that the case type is real property law, we must understand real property. concerning the territory known as the state of New Jersey, which we resort to what we call New Jersey uh, real estate book. Let me just show you the manual right there. Essentials of New Jersey real estate book, 12th edition. All right. Everybody needs to get a copy. It says right here. Just an idea of what it is that we have to understand in the mature, based upon you maturing in this lesson in regards to the voluntary alienation of our intel estate, okay, which resulted as us as areas being considered interstate, okay. Here you have a diagram showing you exactly what the state of New Jersey has done, which is a violation of their oath of office, is a violation of their oath of allegiance, all right, to the government, known then as the crown. Okay? When the heirs were robbed of their estate and robbed of their identity, robbed of their culture, as the 1911 Encyclopedia Britannica says, the Anglo-Saxon Berbers, whose government was known as Wittenmont, and whose code of law was known as the uncoded law called the Magna Carta, where the written Magna Carta, which is reverenced today by the United States as well as the states as the precedents for all bases of law in regards to the common law. And it states here in figure 20.1, when the heirs dies, the process for that property, whether it's personal property, real property, tangible, non-tangible, and we know back then in 1940, I'm parts of 1904, 1704, you had the what we call the Negro Acts, dealing with the regulation of slaves in New Jersey in 1704. Once again, the regulation of Negro Act in 1704 in New Jersey. Very important. The colonies created these codes of law to regulate the heirs now robbed of their identity as property. All right. And conveyed to interstate commerce, which pretty much what you're going through now. And as a result of you having no representation, all right, you're now considered taxable, which means you fall under feudal laws. All right. You're taxed based upon your identity as consumers by the license of the businesses that were created through incorporation by the primogeniture, which is the state. Okay? Any business that's done with the state is known as commerce to them. And when it's dealing with commerce, you have the ability to tax the use of sale based upon the services that are provided to the consumer, i.e. the people. And the people have no remedy at law, which is called feudal relief, as a result of them agreeing to the commercial activity. We here of our religious society are not induced in the commercial activity because, once again, we're not selling chips, Doritos, bean pies, Bibles. All right? We're not selling copies. All right. We're not selling t-shirts, even though we chose to do so. That was not what we were tasked with based upon the purpose and intent of the creation of this religious society. Its main objective was the return of the real property. The return of the real property that was taken from the heirs and then is treated to the state through the first state that really started, which was the state of New Jersey. And then they in return took that land for public use under what they call the eminent domain power of the state, which was called acquisition of land or compulsory purchase of land for the public good, long as that the person or the owner of the property was compensated. Okay. And then as a result of that, the state licensed the stakeholder, i.e., the broker, real estate agent, to be able to uh, sell property, no matter what type of property it is, to the consumer, all right, on the contractual agreement, and then attach an encumbrance known as an easement for the use of that property without the rightful interest or equitable interest in ownership under the process of what we call fee simple, which is a form of conveyance in every state of New Jersey, absent of what we call a legal title. And as a result of that, there's no true ownership, but leaves you as a taxable item. That's the reason why you are taxed for the use and sale of the property when you're dealing with it from a commercial aspect in regards to property. You call it tenancy. Okay? So along with the easements and encumbrances that comes with feudalism, i.e. taxation, you also have the tax that the state imposes upon you through their eminent domain power, through the process of condemnation. And failure to pay that encumbrance results in foreclosure, which is carried out by, as you can see here in the third row, third box to your right, Sheriff Department. This is an open and notorious, continuous hostile crime being imposed upon the heirs through a process of what we call adverse possession. Okay? Adverse possession through what they call acquisition of sovereignty, which is nothing more than the law of discovery. Because prior to the time of discovery, we would do the period of what we call the War of the Roses or the 100-Year War that resulted in a breakdown in the Plantagenet government, which resulted in a breakdown in the Plantagenet grasp on their real estate that was continentally known, all right, as overseas possessions, all right? So within the frame or the lens of the scope that I just identified, please interpret this lesson that in that manner. Okay, so without further ado, let's get started with this marvelous lesson, because this case in which we filed with the Superior Court depends upon it. As you can see, once again, the case type states real property. And real property in New Jersey is governed under Title 46. Okay? Title 46. All right? But before we discuss the real property issue, let's deal with the oath issue based upon their obligation as officers of the King's Council to preserve the Crown estate, which we call Crown land. Okay? This is nothing new. This is neutral information as well as beneficial information to the eternal aspects of the purpose of this movement, and for all those who are participating in the eternal aspects of this movement. For all those who are not participating, this does not concern you. Okay? This does not concern you. You must be a part of the temple. All right? This is a temple that's not encompassed by walls. It's a temple that's not built by human hands. It's a temple that's been guided by the hands of our ancestors. All right? This has been guided by the hands of our ancestors. I'm going to show you without a shadow of doubt. So without further ado, let's get started. I think I talked enough. This is an article found by Archbishop Belmont of the Third Temple English Church of England. An article was a reference to corporation souls. Just to give you an idea of what's the gossip out there based upon the conversations concerning law and their review, their external review concerning corporation souls. Michigan Law Review, Volume 26, Issue 5, 1928, The Corporation Soul. I'm just going to go to an important aspect of this PDF file because I got a lot to cover today. But within the scope of it, you know, what they always say, they say the best for last. They hit you with a whole bunch of garbage. You know what I'm saying? They do the same in case law. You know what I'm saying? They want you to read all this garbage about the case law, and you don't get to the nooks and crannies of the meat until the end of the case. They stick it into somewhere. All right? So this is what I've been tasked with doing. All right? Doing the research for you all who apparently don't want to do the research for yourself. All right? Corporation soul. Let's go to the last page of the article. This is the page 550, the page before the last page. Right? This all concerns the corporation soul, which we know is a natural person occupying a single office, all right, known as the crown, which we were incorporated as, all right? So we must understand what the legal scholars had to say about the internal office of the corporation soul, which is a natural person identified based upon legal historian as the crown or the monarch. It says here the desired ends of a permanence and succession in the institution, however, were never achieved because the corporation soul was insufficiently personified. The court sanctioned a suspension of the legal title between successive office holders. Okay? Nothing analogous to such a suspension can be found in the laws of trust, where the title takes a regular course of descent, never being in abeyance, even though the trustees himself may remain undermined until equity has spoken, i.e., fairness. The fact that the trustee and the corporation soul may each be undermined between successive office holders, which apparently is what's going on now, has led to a likening of the corporation soul to an indefinite succession of a natural person trustee who takes the title without the formalities of conveyance, which means it's an unlawful conveyance. The analogy, of course, is an apt one, but it should not be pressed too far. It should also be pointed out here that the suspension features of the corporation soul, which is so much criticized, illustrates its superiorities over the trust device in at least one instance. If a trustee dies without leaving heirs, the title passes to the state, and the state immunity principles leave the cestus quae without remedy unless the state is willing to make a conveyance to the trustees who has been appointed. We were appointed under 16.1-28, right state under the Charter of Great Britain, saved from repeal, an act to incorporate trustees for religious society for property held in corporations in place thereof. Okay? We must understand that. So if a trustee dies without leaving heirs, the title passes automatically under the term abandoned vacatia, abandoned property. Everybody needs to understand that word or that term. Abandoned vacatia or abandoned property. Okay? Meaning that it falls under the custody of the overseer. Okay? All concerning trustee, all concerning the cestui, all concerning an inheritance, but is based upon operation of law, which does not goes into uh, um, uh, action if the estate is exceeded as a result of interstate, i.e., being there are no more heirs. Okay. So if there are no more heirs, that means that the estate has to be abandoned and it automatically streets to who? The state. All right. And they are the overseers over the estate until the true owner comes and makes the claim. And it ain't the heirs because the heirs ain't there. And property that exceeds automatically by the common law of England reverts to the crown. Okay? It reverts to the crown. So in it states if a trustee dies without leaving heirs, the title passes to the state, in this case, the state of New Jersey, and the state immunity principle leaves the cestus quae, i.e., the trust, the tenure, the fief, without remedy, unless the state is willing to make a conveyance to the trustees who has been appointed. Unless they're willing. Apparently, they ain't been willing. Why? Because they violated their oath to convey it if there was a reconciliation with the crown. Okay? Article 23 of New Jersey's Constitution under the common law, where we have a corporation show the element of suspension bars any estate. You hear that? So where we have a corporation show, which is the crown personified by the monarch, which which entails all crown land, the suspension debars any estate, and we know estate only happens when there's interstate, no heirs. Okay? So we must comprehend what's being said by the historians based upon the language in regards to a corporation soul. These are the scholars. Okay? So if they're scholars, then we must be masters. If we are to take what they talked about and take that and make that into what we call a revelation to a realization by manifest that in his present day through our certificate of incorporation. So now all the rights that our charter has were the rights that the corporation so had based upon those reigning monarchs who sat in the position of a corporation soul. So let's get back to the reason why the state immunity and the principles based upon the state immunity left us remedy no without a remedy. Let's see how we were left without a remedy. As you can see, the website of the Department of the State of New Jersey, which according to New Jersey Revised Statute, Title 52, Section 1, Paragraph 1, it clearly says that they're a temporary government, only for ceremony and commemorative purposes. All right, which means that it's temporary. All right, New Jersey Revised Statute. Let me see if I got it here. Probably not, but Title 52 of New Jersey Revised Statute, Section 1, Title 1, Chapter, was it 52:1-1. It clearly tells you right there that the state of New Jersey, that now sits in Mercer County and Trenton, is a temporary government. A temporary government. Let's go to the primary articles that the state of New Jersey has violated. Article 22 and Article 23, which has a nullification clause. You hear that? It has a nullification clause. Okay? Let's read it in its entirety. That the common law of England, as well as so much of the statute law, has been heretofore practiced in this colony, shall still remain in force until they shall be altered by the future law of the legislator. Such parts only accepted as are repugnant to the rights and privileges contained in this charter, and that the estimable right of a trial by jury shall remain confirmed as a part of the law of this colony without repeal forever. 23. That every person who shall be elected as aforesaid to the member of a legislative council or a house of assembly shall previously to his taking his seat in the council or the assembly take the following oath of affirmation, that I do solemnly declare that as a member of the Legislative Council or Assembly, as the case may be, in 1776, July 2nd, under their temporary government of the colony of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to me injurious to the public welfare of that said colony, nor that shall annul or repeal that part of the third section of the charter of this colony, which establishes that the elections of the members of the legislative council and the assembly shall be annual, not just the legislative council, the council and the legislative council and assembly, but as well as all the other departments and how they appoint their officers based upon the institution of an oath of office and the oath of allegiance. Because we're talking about the oath of allegiance to the office. All right? We're talking about the oath of allegiance to the office. And it says that we're going to start right back from here. I will not assent to any law, vote, or proceeding which shall be to me appear injurious to the public welfare of the said colony, nor that shall annul or repeal that part of the third section in the charter, constitution, and this colony, which establishes that the election of the members of the legislative council and assembly shall be annual, nor that part of the 22nd section in said charter respecting the trial by jury, nor shall it annul, repeal, alter any part or part of the 18th or 19th sections of the same. And any persons or persons, so that means they ain't talking about just the legislative or the assembly, but any other person for that matter. Person or person, meaning in their individual capacity or their aggregate capacity, because we know when they're talking about persons, you're talking about the aggregate, everybody working in official capacity, who should be elected as aforesaid is hereby empowered to administer to the said members of that said oath of affirmation. Here comes the nullification clause, provided always in the true intent and the meaning of this Congress, which we're talking about the Legislative Council and the General Assembly, that if a reconciliation, you hear that, between Great Britain, England, not Ireland and Scotland, because everything they did under the kings of Scotland and Ireland was done on behalf of the Kingdom of England. So they're really talking about the crown of England and these colonies. So when they said the reconciliation between Great Britain and these colonies should take place, and that the latter be again taken under the protection and the government of the crown of Great Britain, this specific charter of July 2nd, 1776 shall be null and void, otherwise to remain firm and inviolable. This is confirmed by the Secretary, by the President Samuel Tucker, as well as the Secretary of State and the Attorney General William Patterson. Everybody sees that. So their oath of office and their oath of allegiance, based upon the true intent of the congressional gathering, was based upon the reconciliation between the crown of Great Britain and the colonies. Okay? Once that's done, the charter, and which gave them their protection and their rights, their limitations, which govern their actions, became null and void. Okay? We must comprehend that. All right? Now we understand that they're talking about the crown. We know that Queen Anne was the queen at that time. And in 1704, they enacted the slave codes for the African American. They were called the Regulation of Slave Act in 1704. Everyone needs to look that up in New Jersey. Regulation of the Slave Act in 1704. At the time of the monarch of Scotland sitting on the crown of England, enslaving the English heirs. It wasn't enslaving the Scottish heirs. They were the ones who were appointed to these offices that we're talking about right now. Okay? Such as who? The first Attorney General for the colony was who? Alexander Griffin. Okay? The first Attorney General under the crown, appointed by who? Lord Cornbury. Edward Hyde, Lord Cornbury of Clarendon. Okay? The Earl of Clarendon appointed him, all right, as the Attorney General for the representation of the crown, its government, its officers, its laws, because that's what the Attorney General do. He represents the state in their official capacity. Okay? So we must understand the scope and the list that I went to protect our estate. Okay? Crown land. In 1702, the Crown Land Act of 1702 was passed by Queen Anne. It's the Act of Parliament of England. It didn't say Scotland, it didn't say Ireland. It said England, originally entitled an act for the better support of Her Majesty's household and the honor and the dignity of the crown. The act was still partly enforced in Great Britain. Okay? For the household of the Majesty, which was called the royal household. Okay? We must understand that. That was the Crown Land Act. We know the Crown Land is personified by the crown, which is the monarch, based upon the demise of the crown. Okay? Another act passed in 1702 by Queen Anne. Demise of the crown, pardon self. Demise of the Crown Act 1702 was an act of the Parliament of England. It didn't say Scotland, it didn't say Ireland, it said England. So it only concerns the crown of England because it was passed by parliaments of England based upon the King's Council. Okay? Based upon the King's Council, which was never in an interregnum. So they should be in operation now as we speak, based upon these acts passed by Queen Anne, who was a Scottish monarch, who preserved the demise of the crown, which means the next transfer from one monarch to the next. Okay? So there we see, based upon the acts in 1702, that there was demise of the Crown Act and the Crown Land Act in regards to the power of that the Crown had in regards to the land, regards to what we call real estate. Okay, very very important for you to understand, and all that involved what we call some oath of allegiance. Okay, of oath of allegiance. Now, before that oath of allegiance was established, we have to go back to the origin of the oath of allegiance that we're used to and the practices that we're used to that were borrowed by the Scottish and the Irish, as well as the United Kingdom and their ceremonial figures who sit now at the head of states, as well as the presidents who are now ceremonial figures who sit at the head of state and their particular municipalities as de facto officers. Not the juror. Why? Because they don't have the power of a sheep. Okay? They have the power of eminent domain, but not the power of his sheep. Okay? That's what we need to question. Who has the real power to exceed that which was abandoned as a result of the heirs apparently not existing or apparently went missing? Okay? The English heirs went missing all of a sudden. Where are they? So the oath of allegiance, judicial or official oath, is a promise to be a loyal to the British, Scottish, Irish, Frankish, Spanish, German, Chinese. You see what's happening to those officials that was under Kim Jong? What's the Chinese Kim Jong? How you pronounce his name, Queen? Kim Jong Ming Ying. Pronounce his name wrong. Forgive me. But when the floods hit that country, he was uh, what you call uh, what do you call it? Executed his officers, all of them. Okay, so you must understand the power that a head of state has. Okay, all right, and that's why you have the obligation of that oath of allegiance that the head of state has in regard to the protection of heirs and successors. Okay, I have a obligation to protect heirs and successors because when we incorporate it, it says the king, heirs, and successors. So when we go back to the origin of the oath of allegiance that we're used to, you see the opening oath deals with heirs and successors. You don't see United States talking about heirs and successors. All right, they ain't talking about no heirs at all. They're only concerned about them based upon their line of succession into that office. They ain't say nothing about a line of inheritance. They said a line of succession. Okay? Very important for you to understand the difference between the two. Okay? So are y'all really voting for somebody to really care about your inheritance when they get in that office? Because they're not dealing with any line protection of any type of inheritance for some person who they're supposed to be representing. They only care about the line of succession, and which is based upon the people who are in line for that office. Okay? So if any brownie points is going to be given, it's about their affiliation and their communication with those. All right? So we see an oath of allegiance, how we understand it, based upon some judicial or official oath, is a promise to be loyal to the crown, to the monarch, and their heirs and successors sworn by certain public servant in England, Great Britain, United Kingdom, and also by newly naturalized subjects and the citizenship ceremony. It didn't say nationalized, they said naturalized subjects. The carriage standard wording of oath of allegiance is set out in a promissory oath act in 1868, as well as in the oath of act in 1688. 1868, pardon something, yeah, 1868. I was wrong. Forgive me. All right. So let's move down dealing with this oath of allegiance concerning us and concerning our heirs and successors based upon the obligation that the monarch has based upon his oath of allegiance pertaining to his position in that government. Okay? So y'all need to know what to look for from your leader. Let's see. The text. The current standard oath of allegiance is set out from the promissory oath of 1868 and the following oath. I insert your full name, do swear that I will be faithful and bear true allegiance to His Majesty King Charles, his heirs and successors according to the law. So help me God. Okay? This is the oath for the United Kingdom. But let's go back before that. Okay? Let's go back to the original origin of the coronation of the oath. Okay? All right, let's go back a little further. Coronation oath of the British monarch. Because we're not just talking about any oath of allegiance to any oath of office. All right, as we see with the United States or the present forms of government, whether it's a commonwealth, democracy, or republic. This has nothing to do with the government that was set up by our forefathers based upon their oath of office and their allegiance to the office of king, which was there for the protection of their heirs and their future predecessors. Okay? So I don't care who don't watch this video. I know what my obligation is. Okay? You should know your obligation because there's an oath required. A coronation oath, which is also an oath of allegiance. A coronation oath is a solemn oath of office taken by the monarch of the United Kingdom at their coronation. An oath has been included in the coronation ceremony since the earliest kings of the English in the 10th century, and their forms was fixed by acts of parliament in the 17th century. So from the 10th to the 17th century, the coronation oath, based upon the oath of office and the oath of allegiance for the king to his his heirs and successors, was a formal practice that was stopped in the 17th century. Why? Because it went into what they call the interregnum, which was a violation of the Crown Act of 17, Crown Land Act of 1702, and the demise of the Crown Act of 1702, passed by Queen Anne. She was the British monarch. Okay, you can't get no thorough than I can. All right. Minor amendments have subsequently been made to the oath to reflect the change in status of the United Kingdom and also the Commonwealth realms, which have the British monarchs as their head of state. The oath has three parts. The first to govern its compliances with the laws and customs of the people, the second to govern justly, and the third to uphold Protestant Christianity and the rights of the Church of England, reflecting the monarch's role as supreme governor of the Church of England, totally different from the English Church of England. Okay, and that was ruled, that was instituted by the kings of the English. So if the kings of the English institute the rules in regards to the oath of allegiance, the oath of office by the acts of the English Parliament, then those instituted by the Commonwealth has nothing to do with the English people, but yet to do with the Church of England, which has to do with those who follow another type of what we call Christianity. Okay, now our form of Christianity. All right, let's go a little deeper. The formation of the coronation service used in England has undergone a number of revisions over centuries. These versions are known as ordines, from the Latin ordo, meaning order, or recensions. The earliest known text of English coronation service, the first recension, is preserved in the 10th century by Leofric Missal. All right, Leofric Missal. Let's see. Leofric Missal. It is uncertain for certain whether this version was ever used in England, but it was possibly used in the Kingdom of Sussex in the mid 19th century or even earlier. There's uh, your resource or reference. Whenever its uses, the text contains the first coronation oath and permissio regis in three parts: the tria preceptor are the three pledges given by the monarch to God. You hear that? See, God is in the equation. All right. All in regards to the his obligation to the heirs and successors. Okay? The heirs and successors. The three promises I give to you that the church of God and all the people will hold true peace under my rule. I forbid acts of robbery and iniquity, and I will uphold justice and mercy in all judgment. The same oath of office based upon the oath of allegiance to the heirs and successors as ordained by God. Okay? And promulgated by his son, Jesus Christ, which to us is who? King Edgar the Peaceful. King Edgar the Peaceful, which is our Jesus Christ, the Vicar of Christ, or as we know as the representative of the anointing, all right, of that being, which was no other than King Edgar the Peaceful, which I'm the reincarnation of in this present day. The same form of oath was retained in the second recension, which is traditionally ascribed to King Dunstan for King Edgar's coronation at Bath Abbey in 973 AD. However, in this later version, the position of the oath and the liturgy moved from being the final elements of the service to one of the first before the consecration, anointing, and crowning. You hear that? There's another reference, all right, resource. The coronation even took form through the time of the Viking invasions that were started by who? William the Conqueror, all right? It was also carried on to Richard the First, the son of Henry II, the son of Godfrey the Fifth Caliban Jew. It also passed to who? Edward the First, the son of Henry the Third, okay? Here go Henry III right there. So these practices in regards to oath of allegiance and oath of office as ordained by God was to protect the heirs and successors. And this is why we incorporated like we did, okay? With the same promises that King Edgar incorporated, okay? It says here, and the first place that he will enjoy, and as far as in his power lies, the king takes care that a true peace should be maintained for the church of God and all Christian people at all times. No wonder he was called King Edgar the Peaceful. Okay? The only king that never had a war during his reign. Okay? As a result of his managing the affairs of God's church. Okay? Because it's all concerning the church, the power of the church. Secondly, that he will interdict all rapacities and all other iniquities in all grades whatsoever. And thirdly, that in all judgment he will enjoin equity and mercy, so that a clement and merciful God may indulge him with his mercy, so that all persons may enjoy a firm peace through his justice. So the Westminster Charter is a reflection of our creation of our charter for the same purpose and intent that King Edgar created his, to represent the anointed of Christ and Christ's successors. Okay? Christ's successors. You must comprehend that. If you don't comprehend it, then you fall under the term called abjuration. Any of you ever heard of the term abjuration? Let's see what that term means. Abjuration. Abjuration is a solemn repudiation, abandonment, or renunciation by or upon oath, often the renunciation of citizenship or some other right or privilege. Did you hear that? Abjuration is the solemn repudiation, abandonment, or renunciation by or upon oath, often the renunciation of citizenship or some other right or privileges. So when you take an oath of allegiance to the United States or the states or any other society that's not formulated by some type of government, by some type of formal process set up based upon your allegiance to that government, then you are practicing the term abjuration. Okay? We must comprehend that. Abjuration of the rim was a type of abjuration in ancient English law. The person taking the oath swore to leave the country directly and promptly, never to return to the kingdom unless by permission of the sovereign. This was often taken by fugitives who have taken sanctuary. So I'm giving you formal notice. I swear on the holy book. You hear that? I swear on the holy book, not holding your hand up. You know what I'm saying? I hope to swear the truth, the whole truth, nothing so help you God. Swear on the holy book or kissing the gospel. You hear that? I swear on the holy book that I will leave the realm of England and never return without the express permission of my lord, the king or his heirs. I will hasten by the direct road to the port allotted to me and not leave the king's highway under pain or arrest or execution. I will not stay at one place more than one night, and I will seek diligently for a passage across the sea as soon as I arrive, delaying only one tide if possible. If I cannot secure such passage, I will walk into the sea upon up to my knees every day as a token of my desire to cross. And if I fail in all this, then peril shall be my lot. Did you hear that? I'm just following orders. Okay? I'm just following order. So we all see what's at stake and to regards to an oath of allegiance. And the oath of allegiance was based upon a ceremonial practice based upon an ancient English law that was taken by oath in which you had to do what? Swear on the holy book. This ceremonial practice is in statutory law in its present day in the state of New Jersey. Did you hear me? Did y'all hear me? Okay? Did y'all hear me? Okay. And let's look at how many monarchs kept this practice going on. Okay? How much our ancestors love us so much that they kept this practice uh 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 and in the loop. Okay? We just forgot it. Yeah, Archbishop, I said the same thing. Wow. All right, let's see. Oh, a little bit more hotter. 1 minute. So this is who we have to give thanks to. Okay? This is who we have to give thanks to. All right? All right? Alfred the Great. And his wife, Elizabeth. Edward the Elder. Edward the Elder uh, had uh, had a had the sons. Edmund the First. All right, Edward and Asherton. Asherton was the son of Edward the Elder. You had Edward Asherton, which means noble stone. Edmund the First, and you had Edred. Edred was the son of Edward the Elder as well. Edmund was the father of Edwig and Edgar, and they were too young to rule. So Edred, which were their uncle, came to rule where Edmund died. And all the councils that attended to Edmund the First, the son of Edward the Elder, the son of Alfred the Great, all right, kept the preservation of the English Benedictine reform. Okay? We must comprehend how important our church is to us. Edwig, which was the brother of King Edgar the Peaceful, our Jesus Christ. All right? King Edgar the Peaceful brought it to a peaceful unification. Okay? And 959 to 975, it was peaceful until his children came to reign. Edward the Martyr and then Ethelred the Unready. As a result of what? Marriages. Okay? Marriages. We must comprehend. Ethelred the Martyr, Ethelred the Unready. Then you had the invasion. We know when Wolfton said that the reason why Vikings invaded us because we disobeyed God. And who we have to thank for that? The House of Denmark. Okay? But even the House of Denmark, who invaded England, complied with the law that was carried out through the time of Alfred the Great. We must understand that. My wife's family line descended down from Galveston. Okay? How they're complying with the laws based upon their oath of allegiance and their oath of office to protect the who, everyone said, the heirs and successors. The heirs and successors. All right. So we have swing fork bearer. Then the house is restored to who? Ethelred Dunready. Edmund Ironside. Okay. Then Danish take over again to the last king who? Edward the Confessor. Okay? Edward the Confessor. Right there. We know our family. We know our family line. Okay? I could go on for days, but for the sake of time of the class, I'm not going. We're going to move forward. Okay? So we have to understand that how important it is to understand our incorporation of the church, our oath as members of the church, as well as officers, as well as the king, to protect the heirs and successors. That's why our name was incorporated based upon this oath. Now let's see how, as it said, how the oath was supposed to be done based upon what? Kissing the book. Kissing the book. All right? Kissing the book. All right, so this is a practice that started in England. Right? It's supposed to start over there in England. So how did it wind up over here in the modern day statue? That's what I want to find out. How? Where is that at? Kissing the book. I just read that. Where did he kiss the book at? Oh, abjuration. Abjuration of the rim. Let's look. Right? Abjuration of the rim was a type of abjuration in ancient English law. The person taking the oath swore to leave the country directly and promised never to return to the kingdom unless by permission of the sovereign. This was often taken by fugitives who had taken sanctuary. I swear on the holy book. You hear that? Swearing on the holy book. Very important because this practice was maintained through the statutory law as created in the laws of New Jersey. Let's see. Oath and affidavit, oath of allegiance. Oath of allegiance form. Every person who or shall be required by law to give assurance of fidelity and attach to the government of the state shall take the following oath of allegiance. You hear that? I do solemnly swear that I will support the Constitution of the United States and the Constitution of the state of New Jersey, both, and that I will bear true faith and allegiance to the same and to the government establishment and the United States and the state under the authority of the people, so help me God. So when we go back to Article 22 and Article 23, you are obligated based on your oath of office, even under the new Constitution, to hold your office when that reconciliation of Great Britain took place when they reconciled with the crown. The colony reconciled with the crown. That has taken place with our incorporation. That means that whatever oath that you took with the United States or the states is superseded. Why? Because you violated through abdication. Because why? Now you got to kiss that bull. I'm gonna make you kiss that bull. Why? Let's see. Let's see. Oath of affidavit. Take it with the hand instead of kissing the scriptures. Do y'all see this? Revised statute, oath of affidavit, oath taken with the hands instead of kissing the scriptures. oaths taken with hand instead of kissing the scriptures. It should not be necessary to the solemnity or obligation of an oath administered in any court of justice or any legal proceeding, civil or criminal in this state, for the person taking the oath to kiss the holy scriptures, but taking of such oaths while the hand should be held upon the book shall answer all the purposes and requirements of the law. Any uses or custom to the contrary heretofore notwithstanding. If any person so sworn shall swear falsely, they shall be guilty of perjury as though the book had been kissed. Did you hear that? Did y'all hear that? Okay? This is all about kissing the book, taking an oath of obligation to protect your way of life. Here's another statute, 41:2-1, official authorization to take oath. Let's see. All oath, affirmation, and affidavits required to be made or taken by law of this state or necessary or proper to be made, taken or used in a court of the state or for any lawful purposes whatsoever may be made and taken by any of the following officers. Okay? Chief of the Supreme Court of any of the judges of the court recorded in the state, masters of the Superior Court, municipal judges, mayors or aldermen of the cities, towns and boroughs, commissioners of commissions, government municipalities, surrogate registrars of deeds and mortgages, county clerks and their deputies, municipality clerks, clerks of board of chosen freeholders, sheriffs of any county, members of the board of chosen freeholders, clerks of all courts, notaries of the public, commissioners of deeds, members of the state legislature, attorneys at law, and counsels at state of this law. Certified court reporter as defined in Section 10 of Public Law 1940. This section shall not apply to official oaths required to be made or taken by any of the official officers of this state, nor to oaths or affidavits required to be made and taken in open court. Yeah? Oh, yeah? Let's see what case law say. All right? Let's see what case law say. Here's another one before we read what the case law say. Another one, 41:2-18. The president of the Council of Proprietors of West Jersey, you hear that? Proprietors of West Jersey. Now, we know they surrendered their authority back to the Crown in 1702. And from that time on, to the present, based upon the demise of the Crown Act and the Crown Land Act, nothing has changed since then. Okay? Because it just said here, the president of the councils of the proprietors of West Jersey, or in the absence, the vice president or the president pro tempore may administer oath or affirmation to witnesses touching any dispute or controversy that may come before said council for their adjudication. Did you hear that? Did you hear that? All right. Why is this important? Let's go to Embry versus Marsh. Let's go to Embry versus Marsh. Everybody see that? Write this case down. Embry versus Marsh, 1950 Supreme Court of New Jersey. This is from the Supreme Court of New Jersey. Look what it says, y'all. Indeed, the history of oath of allegiance and other tests for office holding in England and in the colony of New Jersey constitute convincing proof of the historical unsoundness of the defendant's contention, as well as persuasive support of the exclusive nature of the oath incorporated in our Constitution. You hear that? This history is an involved one, but the matter is one of such paramount importance and not without present-day significance that we deem it essential to go into matters at this point. The most compact summary I have been able to find of the history of my oath of allegiance is from the pen of the most brilliant of English legal historians. Did you hear that? English historian. Let's see what they say. The history of the parliamentary oath and religious disabilities began in 1562 with the statute of Queen Elizabeth I, which required every member of the House of Commons to take an oath of supremacy to swear that the Queen is the only supreme governor of this realm, as well in spiritual as in temporal causes, and that no foreign person or potentate has any authority, ecclesiastical or spiritual, within this realm. In 1609, an oath of allegiance was added by King James the First. King James, King James the First, yes. All right. To the effect that the king is lawfully king and that the Pope had no power to dispose him. Did y'all hear that? The Pope has no power to dispose him. To these oaths was added a declaration against transubstantiation, the invocation of saints, and the sacrifice of the Mass, and the two oaths. This declaration will require of lords as well as commons. Okay? The doors of both houses were thus effectively closed to members of the Roman Church. Some of them might be ready to take the oath which related to church government, but the declaration as to the doctrine was utterly incompatible with their most fundamental beliefs. Immediately after the revolution, the two oaths of allegiance and supremacy were altered and formed. Did you hear that? Did y'all hear that? Immediately after the revolution, the two oaths of allegiance and supremacy were altered and formed. The first was to be merely this: I will be faithful and bear true allegiance to the King, William, and Queen Mary the second, and was I do abhor as impious and heretical the damnable doctrine and position that princes excommunicated by the Pope or any other authority of the See of Rome may be disposed or murdered by their subjects or any whatsoever, and I declare that no foreign prince or person has or ought to have any jurisdiction or authority, ecclesiastical or spiritual, within this realm. Did y'all hear that? Did you hear that? The declaration against transubstantiation was still maintained. An act of 1701 added a third oath known as the Oath of Abjuration. It is the long and of more political character. The swearer abjures all allegiance to the pretended Prince Wells, and promised to maintain the royal succession as fixed by the Bill of Rights and the Act of Settlement, and this he does upon the true faith of his Christian. You hear that? We understand the Bill of Rights and the Act of Settlement was based upon those who became citizens based upon the Act of Settlement Act under the authority of Elizabeth I, who was the daughter of Henry VIII, the son of Henry VII, the founder of the House of Tudor. We understand that that's where citizenship came about in regards to Calvin's case, but there's only four types of citizenship: those that relate to what we just read in this paragraph, those that came through the Naturalization Act of 1790 dealing with the founding fathers, those through the 14th Amendment dealing with those who emancipated from slavery, i.e., the English heirs. You hear what I'm saying? And those through the Immigration Act, what we call the Immigration Act. All right? Dealing with those who immigrate to North America. Only four qualifications. Y'all better hear me. The persons who were thus excluded were members of the Roman Church, persons who objected to oath, and persons who were not Christians. Quakers, we may say, and Jews. In 1696, the oath of allegiance and supremacy were required of the electors as well as the elected, and the electors had also taken the oath of abjuration. You hear that? The oath of abjuration. We all know what abjuration is, right? Has to deal with you citizenship. All right, violating your citizenship of your mother country. We must understand that, right? It has it right here. I urge us, it is urged on us that there was an oath for the legislators prescribed by the Constitution of 1776, but that notwithstanding the existence of this oath, the legislature promptly enacted an oath of allegiance. A constitutional oath for the legislature is embodied in the final article of the Constitution of 1776 and must be quoted in full because of the light which it sheds on the nature of that Constitution, i.e., the nullification clause. Article 23, that every person who shall be elected as aforesaid to be members of the Legislative Council or House of Assembly shall, previous to his taking his seat in Council or Assembly, take the following oath of affirmation. Okay? I do solemnly declare that as member of the Legislative Council or Assembly, as in the case may be, of the Colony of New Jersey, I will not assent to any law, vote, or proceeding which shall appear to me injurious to the public welfare of the said colony, nor that shall annul or repeal that part of the third section and the charter of this colony which establishes that the elections of members of the Legislative Council and the Assembly shall be annual, nor that part of the 22nd section of that said charter respecting the trial by a jury, nor shall annul, repeal, or alter any part of the 18th or 19th section of that same dealing with freedom of religion. And any person or person who shall be elected as aforesaid is hereby empowered to administer the said members to the said oath of affirmation. Okay? It is important to recall that the Constitution of 1776 was a revolutionary document adopted 2 days before the Declaration of Independence without any ratifying vote of the people. After 2 days of drafting its committee, 2.5 days of discussion by the Committee of the Whole, and 1 day of deliberation of the Provincial Council, Erdman, New Jersey Constitution of 1776, as will be seen from Article 23, okay, above quoted, the Constitution of 1706 was deemed by its framers to be merely a statute, albeit an important statute of a type of Magna Carta, but nevertheless a statute amendable by any legislator created under it, except insofar as the oath of the members of the legislature precluded them from amending the 4 articles of the Constitution enumerated in Article 23. With this view of the nature of the Constitution, it cannot be contended that the oath of allegiance of September 19, 1776 was in any wise unconstitutional. Okay, let's read a little bit more before I move forward. Judge J. Alford dissenting in the opinion. It is important in this discussion to bear in mind the distinction between an oath of allegiance and an oath of office. An oath of office needs no definition. It is self-defining. I deem it necessary, however, to state my understanding of what an oath of allegiance is under our form of government and to whom and what form of allegiance is due. Listen very closely. Allegiance is in its application to the subject of a sovereign goes back to early English history. Lord Coke says allegiance or allegiance is that lawful obedience which a subject is bound to render to his sovereign. Calls it the tie or ligamen which binds the subject to the king in return for that protection which the king offers the subject. Did you hear that? Which the king offers the subject. There are marked distinctions between the allegiance of due by a subject and the allegiance due by a citizen, which need not be elaborated on here. When we speak of citizens, we mean the people of a free government and the relations in which they stand to their government, incurring as it does an obligation to support the institution of freedom thereunder, and every citizen and officer thereof is bound to your obedience to that government. With us, the people organized as a government are sovereign, and the citizens owe a duty to that sovereignty. You hear that? Let's see where we at. It's going to narrate what we read in Article 23 of New Jersey's Constitution, the nullification clause, before I move forward with this lesson, if I didn't miss it. right here. Okay, right here. This is the historical fact of the matter. Although I agree with the majority that the 1776 Constitution was deemed by its framers to be a statute, albeit an important statute of the type of Magna Carta, but nevertheless a statute amendable by any legislator created under it. Besides Article 22, the Constitution of 1706 contained the following language, provided always in its true intent and meaning of this Congress that if a reconciliation between Great Britain and these colonies should take place and to later be again taken under the protection of the government of the Crown of Great Britain, this charter should be null and void, otherwise remain firm and inviolable. Did you hear that? Did you hear that? At this date, I do not think it necessary to deal with the abstract question as to where the sovereignty rested in those embattlement moments in our history. The revolutionary government of the new nation and of this state consisted of Continental Congress, the Articles of Confederation, and our own revolutionary Constitution of 1776. I have noted that the Constitution of 1776, and particularly Article 23, contain no oath of allegiance as such. The oath set out therein an oath of office rather than a oath of allegiance. Okay? So you must understand as a result of that, that's abdication as a result of you're allowed to even come here as a citizen. All right? It's very important that we comprehend what it is that we're reading. Because we know in New Jersey, under the New Jersey Professional Council, the authority that was here before they created their Constitution of 1776 was under the authority of who? The Crown. The Crown. We see it. The Provincial Council was established in 1702 upon surrender of the proprietors of East Jersey. Those of West Jersey are the right of government to Queen Anne and Queen Anne's government, which unites the province of New Jersey as a royal colony, which then created a fusion of power of the legislative, executive, and judicial branch. Okay? We must comprehend what is going on because apparently some of you don't. Okay? Let's see. Let's see. So, as stated under the oath of allegiance that was practiced by our ancestors, specifically King Edgar the Peaceful, Mark Weiner, who wrote From Kin to King, gave a narrative of that. He states in the chapter From Kin to King of the Anglo-Saxon England, he said 973 in a abbey in Bath, a great Anglo-Saxon king lay prostrate before an altar while the Archbishop of Canterbury wept with joy. The king was Edgar the First, known as Edgar the Peaceful. And at age 13, he was in his 14th year of a seemingly successful reign. Under his rule, England revamped its currency, streamlined its central administration, sustained its military authority over a one rest of Islam, and recognized its counties along lines that will remain essentially unchanged until 1974. The Archbishop was Dunstan, a determined reformer of the English Church, advocated for his monistic interests, overcome by the king's humility, and is saying to him, Te Deum through his tears, we praise thee, O God. We acknowledge thee to be the Lord. A half century later, he will be canonized as a saint. The occasion for Edgar's pious self-effacement and Dunstan's joy was the king's coronation, i.e., these oaths of allegiance. Tellingly, the ceremony was held on the Pentecost when Christians celebrated the descent of the Holy Spirit of the Apostle, i.e., the anointed. The age of the king, too, was significant, the same as which Jesus began his ministry. Did you hear that? The ritual began when Edgar, wearing the crown and holding a scepter, was led into the abbey by a parade of white-robed clerics, a crowd of priests, and the words of the Anglo-Saxon chronicles, a throng of monks and a council of sages. The ensuing ceremony was filled with all the pageantry of the great world events in England today. The king would be anointed with, pardon self, the king will be anointed with holy oil from the animal's horn. He will be giving a ring, a sword, a crown, a scepter, and a staff as a symbol of his rule. And the abbey will resound with the joyous anthem from the first kings, the Zolak priest, Nathan the prophet, or Melchizedek, king of righteousness. But in constitutional terms, the most important part of the ritual came when Edgar spoke, shortly after clerics raised him from his position of humility before the altar. For it was then that he swore his coronation oath, making a public promise to rule according to certain principles. He swore his words have echoed as loudly across constitutional history as the anthem of the Zolak priest, echoed in the abbey at Bath that day. And in the name of the Holy Trinity, I promise three things to the Christian people, my subjects. I declare first that God's church and all Christian people of my realm should enjoy true peace. And second, that I forbid all ranks of men robbery of all wrongful deeds. Third, that I urge and command justice and mercy in all judgments, so that the gracious and compassion God who lives and reigns may grant us all his everlasting mercy. And we know that as through his reign, we see that everything that was stated happened in regards to his reign, being that it was all peaceful. So in modern terms, the king had pledged, i.e., took an oath to protect the English church, not the Church of England, to safeguard public order by applying the law to all persons regardless of their rank. Just as it was done in the beginning, so shall it be done in the end. And to govern according to an abstract Christian idea of justice. Edgar Pledge is the first coronation oath in Anglo-Saxon historical record, and though it may not have been the earliest ever taken by an English king, it clearly marks Anglo-Saxon government as having come a long way from its roots in a very different way of life. What are the preconditions for modern clan societies to develop the rule of law? What are the fruits of the transformation? The English Middle Ages, the stories leading to Edgar's coronation oath and beyond offers what? Everyone said, important clues. All right. So why is this important? Because the same thing we just read is echoed in the 1911 Cyclopedia. Okay. The 1911 Cyclopedia. Right. All this concerns the oath, which we talked about kissing the book. Okay. Kissing the book. Where is it at? I ain't got time to go there. Let me move forward. Okay. So let's move forward. So in closing, the crown. Okay. The crown, which I represent, okay, or the concept of the crown. Everybody hold that thought. That all right. So the crown. Anybody who doubt I don't know what I'm doing, you either ask yourself again, all right, based upon the concept of the crown, not because what I think it is, but what they say it is. Okay, all right. I'm gonna show you the abstract, and I'm gonna show you the concrete in closing. Just based upon the language of the concept of the crown. The concept of the crown took form under feudal system. Feudal system is a system that deal with taxes. Okay, because feudal means fee, tax. Though not used this way in all countries that had the system, in England, all rights and privileges were ultimately bestowed by the ruler. Okay, listen very close in closing. Land, for instance, was granted by the crown to lords in exchange for feudal services, and they in turn granted the land to lesser lords. That's called subfeudation. Okay? One exception to this was common socage. All right? Owners of land held as socage held it subject only to the crown. So there was no landlord or there was no tenant. There was no immediate what they call third party. It was either the grantor and the grantee. In this case, it was the crown. Okay, which in this case would be what? The minor. All right, all it's gonna be right here. One exception to this common soakage, owners of the land held a soakage, held it subject only to the crown. When such land became ownerless, all right, meaning when no one as an heir owned it, it became what they call escheated. Okay, let me show you the video again before we close. One teach you real estate law like this. So when there are no heirs in a real estate action, conveyance of real estate action based upon an estate, an intel estate, because crown land is an intel state, all right, personified by the monarch, which is inseparable from it. So if there's no heirs, then the only person that the land can escheat to is the crown, i.e., the monarch. All right. If the monarch is not there, then it means it falls under the eminent domain power of the state of New Jersey or any state for that matter. Okay. Very important. All right. Property is taken, which becomes bona vacant tina. Okay. It's not subject to the common law of bona vacantina or the common law of abandoned property. Because if under the common law of abandoned property, if there's no heirs, the king takes it. Okay? If you're not using the common law, then that means it is ceased to the state of New Jersey under the eminent domain power. All right? Very, very simple. So in the concept of the crown, it says here, I repeat, one exception to this was common soakage. Owner of lands held as soakage, remember that term, held the subject only to the crown. When such land became ownerless, i.e., no heirs, they are said to escheat, i.e., return directly to the ownership of who? Anyone say it, the crown. And it says in quotations, crown land. So what is crown land? Only I can do this, y'all. Crown land, also known as the royal domain, is a territory area belonging to the monarch who personifies the crown. It is equivalent of an intel estate and passes with the monarchy being inseparable from it. Did everyone understand that? So it belongs to me, all right, to preserve for you once you recognize who you are. Because apparently you didn't, and that's how you lost it in the first place. And now fell under the custody of the state in which you now reside as abandoned property. Okay? Bona Baker Tenia. Okay? So when such land become ownerless, all right, meaning that you gave it up because it was through ignorance or through force, all right, through acquisition or compulsory or eminent domain power, it was supposed to go directly to the owner, i.e., the crown. As it said, when such land became ownerless, i.e., it is sheets because no heirs, they are said to escheat directly to the crown. Bona vacatinia is the royal prerogative by which unowned property, primarily unclaimed inheritance, you hear that, becomes the property of the crown. So unclaimed inheritance associated with property under the crown's royal prerogative becomes bona vacatia, i.e., abandoned property. Automatically, in regards to inheritance, belongs to the crown. Everybody read that? So bona vacatina belongs to the crown. Okay? Let's see. Ordinance colon 32-1. Certain tenures, honors, lands, tenements, or hereditaments, or estates of inheritance at the common law, held either of the King of England, all right, or other person, or body parts or corporate, remain in free and common soakers, right? Why? Because it's held by the crown, because it's crown land personified by the crown, which is the minor. And if it is no heir, then it's Bona Baker Tina. It's abandoned property. And if it's abandoned property, then guess what? Let's read it. Ordinance called 30B-9, when property is subject to custody. Sorry about that. Okay. When property is subject to custody. When property is subject to custody, unless otherwise provided in this chapter or by other statutes of this state, property is subject to the custody of this state as unclaimed property if the conditions raise a presumption of abandonment under Article 2 and 5 through 16 of this chapter and are satisfied, and the conditions under 4630B-10 are satisfied. The common law doctrine of bona vacatina still remain viable with respect to unclaimed property not covered by this chapter or another statute of the state. I repeat, the common law doctrine of bona vacatina should remain viable with respect to unclaimed property not covered by this chapter or any other statute in this state. Let's see what Abbott versus Beth Israel say about that. Okay, and close from the Supreme Court of New Jersey. Supreme Court of New Jersey, 1953 case. The power of eminent domain is a high sovereign power. So not only does the state not have eminent domain power, they don't have the power to escheat, because both of those powers revert back to who? The crown. I didn't say it. The case law said it. Supreme Court said it. The power of eminent domain is a highly sovereign power that has been allotted to the legislative branch of the government since the Magna Carta. See Blackstone's commentaries. It has been held that constitutions do not give, but merely place limitations upon the power of eminent domain, which otherwise will be without limitations. Okay? The proof above statement may be succinctly demonstrated by Clause 39 of the Magna Carta, provided that no free man shall be deceived unless by the lawful judgment of his peers or by the law of the land. This was the apparent common law origin of the placement of the sovereign power of the eminent domain and the legislative branch of the government. Blackstone commentaries state that there is no doubt that the power remained so ensconced at the time of the American Revolution, and this fact is attested by the authorities hereinfore cited. The Constitution of 1776, by its specific terms, was a charter for the government of the County of New Jersey. New Jersey Constitution 1776 to be a temporary departure from the government of the Crown of Great Britain. Did you hear that? Did you hear that? That the common law, pardon so, that the common law of England, as well as so much of the statute law as have been heretofore practiced in this county, shall here still remain and enforced until they shall be altered by the future laws of the legislature, and such parts only exceptions as repugnant to the rights and privileges contained in this charter. We see that? Let's see here. Where is it? Yes, a temporary departure. Where's that? This case for another case. Let's see. Oh, I got it. It was state versus elevator. All right. State versus elevator. I apologize for that. State versus Otis Elevator Company, 1953. When we're talking about revised statute 4630B 9, when property is subject to custody, it says that the common law doctrine of bona vacatio still remains viable. Very important. It still remains viable. So let's see what it states in State versus Otis Elevator Company. All right. And modern usage, in closing, and modern usage, a street signifies the falling of property to the sovereign for want of an owner. Okay? So when there's no heirs, it falls in the interstate and automatically streets because ain't no heirs and ain't no owner around. So when it streets to the state, through the state eminent domain power to take private property for public use and with just compensation. We ain't been compensated for this yet. So minor usage is street signifies the falling of property of the sovereign for want of an owner. And this category embraces not only property which has no other owner, but also property whose owner or whose owners' whereabouts is unknown. They're talking about y'all. Under the common law of England, estates came to be classified as another branch of the king's ordinary revenue. Was ordinarily an incident of tenure is now an incident of sovereignty. You hear that? Incident of sovereignty. The doctrine of escheat as the early common law operative only upon that which was the subject of tenure, since related to the reversionary right of the lord to take for one of a tenant, was eventually extended to include personal property, intangible and intangible. The principle was that the right to take that which belonged to no one appertained to who, y'all? The crown, as part of what they call the crown's jewel regalia, has to do with the king's radical title. The crown steps in to take the property because it is vacant. Property described as bona vacantia is taken or assumed by the state under the laws of presumption as its own. Property of this class falls to the crown as a matter of right and the exercise of its sovereign power. Okay? Of its sovereign power. In personal estates which are allodial by law, the king is last heir where no kin. Did you hear that? The king is last heir when there is no king. So that's the purpose of why your king files this lawsuit on behalf of the heirs and successors. All right? In lieu of the violation of the oath of office and the oath of allegiance based upon their oath of affirmation for the reconciliation with Great Britain once the states come back under the protection of the crown based upon the crown's representative, which happens to be who? The plaintiff. Okay? Happens to be the plaintiff. Okay? And as a result of that, I was arrested trying to take back the property. And as a result of that, your king had to file a lawsuit, which you see here, to retake the property. Okay? To retake the property. I had to get a donation from my brother Millichin for the amount of $300, which I had to pay back out of my own pocket. All right? You know, we're open to gifts and donations, which is free and common soakage, which you should, based upon your oath of allegiance, should be rightfully given for my protection. All right, for an interest in the inheritance in the state that you so-called say you have an interest in. Okay, but right now I don't see that the people have an interest in their estate because they're not concerned about their present concerns, like we are here at the Third Temple English Church of England. So with that, let me see. I'll make sure I covered everything. Yes, I covered everything. So with that, we must understand, based upon New Jersey by statute 46 colon 30B-9, that the common law rule for the doctrine of bona vacantia remains viable, and the only one that reclaim that property is the king. All right? Because as it said in New Jersey by statute, the land is in fact and indeed allodial, which I'll show you before I close out. And when land is allodial, the king is rightfully the owner when there is no kin. 46:3-6, give grants and conveyances by the state of New Jersey or anybody who within the state that has some type of tenure, whether it be under feudal law or whatever, it belongs to the crown. All gifts, grants, or conveyances made prior to and after July 4th, 1776 of any state of inheritance by letter patent under the great seal of the state or any other manner by the state, by the legislator thereof, or by the commissioner or agents of the forfeited state, by other lawful and competent authority under the state, shall and remain allodial and not feudal, and shall forever be in continuing free pure allodium only, forever discharge of feudal tenures and interests thereof, and all other services whatsoever. So if you have a tenured here, your services and that tenure based upon your commercial practices are no longer needed. All right? No longer needed. All right? We can fend for ourselves. All right? You must make sure that you are, in fact, one of the people. One of the people. Okay? So I love you all. I hope you all are maintaining and retaining what's being said to you, because I'm looking for other members to fill a role as counsel. All right? Attorneys. All right? Members who went to law school. All right? Teachers. Members of your general councils, your city board, health boards. These are the people I'm looking for. All right? Take your place in the affairs of the English. All right? From there, you have your remedy. Your remedy for feudal relief to stop these taxes. Is their obligation and the oath that they have violated. And as a result of that, your king has filed a lawsuit. You see it here. You show me one person of any society, of any group, of any nation, of any people who have filed the suit on behalf of the heirs and successors as the King of England and can lawfully prove it. Can lawfully, you see it, jury demanded. Jury demanded is ball game, y'all. They locked your king up, and that's the evidence to support the civil complaint based upon the malicious prosecution, which is not has not yet been indicted after close to 8 months. Which the only affirmative defense is to file a civil complaint against the state for the property that rightfully belonged to your king and his heirs and successors. Okay? Thank you, Archbishop, for the closing remarks in regards to each and every member's obligation to their oath and allegiance and their oath of office just as a member. Just as a member. Okay? Please take this to all the avenues out there. Any avenue, any platform that's out there that's willing to do a live with your king. Publicly. All right? Not behind closed doors, but publicly. All right? Who has a large following. I'm not in it for your members. I want y'all to be part of the church. That's my whole purpose. That's our whole intent. And that's our whole drive. All right? It's to save as many souls as we can. Many are called, but few are chosen. And if you're watching this live, then you are the chosen. You just have to come. And with that, I'm going to greet you as I always greeted you. That's in peace and love. Send your comments, not just in the chat line, but as well as on the actual post. I don't want to hear nice lesson or great job, King. Show me that you understand these lessons. Show me some remarks that detail and give a syllabus other lessons for you, for those newcomers. Okay, for those newcomers to put some of those old people who've been here in the back seat. All right, let me know you coming into this with your eyes wide open. Okay, your feet hitting the pedal. All right, let's do this, y'all. We got work to do in the year 2974. All right, and the time to work is now. So with that, thank you, Archbishop, for your moderation, as well as all those who are rightfully planted in the soil best suitable for their growth. All right, you will receive this life-giving water as much as it's dispensed to me by my ancestors. So for this task, I'm greatly honored to be able to one to speak on behalf of the Vicar of Christ, which is the crown representative. All right, and with that, I say peace. All right, Bishop, make sure you post the template for this actual lesson. And the next one we're gonna do is gonna be uh the eminent domain power of the state is a fraud. The eminent domain power of the state is a fraud. That's going to be my next lesson. All right. Thank you, Brother Arthur McGarrell from the House of McGarrell, for your blessings. I hope you like the lessons. If you're going to comment, make sure you give a comment, not on the chat. You're welcome, my son. But give it on the actual YouTube so that way I can read your comments there because once I close out, I'm not able to read the chat until it posts on the next day. Okay, so leave some comments and leave a worthy comment so that you can understand and see that you're not just watching this video, but that you truly comprehend because that's going to dictate if you are considered a child of God. Okay, that's going to determine if you're a child of God, if you comprehend what's being said to you. Because you know anything the mind says, the body will follow, and it's not the other way around. So with that, I say peace.